of the two witnesses has been occasioned by the failure of the legal team to ensure that 3.3 notices, that is, notices to implicated persons to enable them to consider evidence and apply to cross-examine, have not been issued. There was a decision or a proposal at least that in order to reduce formalities, the need for formal applications such as the present could be obviated. But it has now been determined in consultation with yourself, Chair, that this particular application is necessary despite that intention to reassure the public and to reassure interested parties that despite the logistical and capacity challenges that the Commission is facing, it does regard compliance with its rules as a serious matter. And in going through the rules, it may be that those rules need to be changed in one form or another to facilitate the continuous giving of evidence before the Commission. So I will take some time for that reason to explain, not for your purposes, but for the benefit of implicated parties who may be witness to this particular application, and for the public at large to understand the rules and how they operate. Chair, Rule 3.3 of the quite comprehensive set of rules that govern the operations of this Commission states quite clearly that if the Commission's legal team intends to present to the Commission a witness whose evidence implicates or may implicate another person, it must, through the Secretary of the Commission, notify that person in writing within a reasonable time before the witness gives evidence. And that notification involves a number of steps and a series of pieces of information that must be provided to that witness. But essentially, the notice serves two purposes. The first, it allows a person to make arrangements to attend and hear the evidence of the person who is the witness. And secondly, to enable that person a period of 14 days, 2 weeks, says the rule, to consider his or her position as an implicated person, to obtain legal advice if necessary, to then apply to you, Chair, for the leave to cross-examine. So that is essentially the twofold purpose of a notice in terms of Rule 3.3. Rule 3.3.6 says that if a implicated person wishes to give evidence, to call any witness to give evidence on his or her behalf, or wishes to cross-examine the witness, he or she must, within 2 weeks from the date of the 3.3 notice, apply in writing to the Commission for leave to do so. And then the provision is that you, Chair, will decide the application. Rule 3.4 states that the application to cross-examine or to give evidence or to call another witness to give evidence must be made within 14 days from the date of the notice referred to in 3.3. And 3.5 then provides that if any implicated person believes that he or she has received inadequate notice, then he or she may apply to the Commission for such order as will ensure that he or she is not seriously prejudiced. Now, Chair, in summary, a witness is to be called, notice is given to an implicated person of the nature and extent of that evidence. That person then has 14 days to make application, to give evidence, to call a witness, or to cross-examine the witness concerned. And that implicated person has 14 calendar days to do so. That is the scheme of Rule 33234, and of course if a person who is implicated believes he or she has been prejudiced, there's provision for relief to be granted. That is the scheme of the rules. But, Chair, importantly, that scheme was predicated on the assumption that a witness would be called, due notice having been given, and a 2-week period preceding the evidence having been provided for, and in that period, all the applications for cross-examination would be heard, the implicated person would be given an opportunity to respond thereto so that a witness could come and give evidence, and then immediately be cross-examined. That was the idea. That has proved unworkable for a number of reasons. Firstly, Chair, if the legal team and the Commission Secretariat does not know how long a witness is to give evidence for, and for how long and by how many people that witness will be cross-examined for what periods of time, it is impossible to plan in the medium to long term for a continuous stream of evidence. So what has happened as a matter of practicality is that evidence in chief has been planned, given, and we can therefore ensure reasonably continuous presentation of evidence without gaps in between occasioned by uncertainties. The other problem that has occurred in practice is that coordinating the dates and availability of various legal teams, all to be available at a particular pre-planned date without notice to those legal teams for cross-examination, has in our experience not been possible. So the solution that has been implemented by the legal team and the Commission in consultation with yourself, Chair, is that witnesses come, they give evidence in chief, then there is a postponement for the purposes of cross-examination. So where a witness's evidence is postponed for cross-examination, there's no prejudice, in one respect at least, to implicated persons, because they have a long period then to consider their position, to make application, and then dates can be arranged with the various legal teams for cross-examination to the convenience of all. The problem, however, is that the notice serves another purpose, and that's to arrange to be present to testify. And for that reason, at least some notice is required, if not 14 days, to enable lawyers or implicated parties to be present to hear evidence. That prejudice is alleviated somewhat by the fact that if someone is not present physically to hear evidence, evidence is televised, it's available on record, written statements and bundles are available or are provided to implicated persons. And so that prejudice is somewhat alleviated by the circumstances which prevail here at this venue with the televising of witnesses and their availability electronically of a record. One of the amendments to the rules that may be considered is that the reasonable time should be given to witnesses, rather to implicated parties, before cross-examination, rather than before the witness gives evidence, provided that there's sufficient notice to the implicated parties to enable that party to attend, which may not be a formal Rule 3.3 notice, but another form of notice. But, Chair, the legal team is considering the position and may make representations regarding a different order of things for the future, because after the break in April, the pressure on the Commission will be enormous, and much greater than the pressure that the Commission is presently experiencing. The application has also been necessitated by the fact that matters were not attended to by the legal team. The legal team takes full responsibility for that. Nevertheless, having said that, there are logistical challenges. which we needn't deal with in public, capacity and legal challenges which are being dealt with at present and are referred to in the application. So, Chair, that by way of background, provided a witness gives evidence in circumstances where an implicated party has notice of the fact that that person is giving evidence, and provided an implicated party has ample time, at least 2 weeks, and in this case it will be more, to consider his or her position, brief counsel, or seek assistance from the Commission itself, to prepare an application for cross-examination or to lead evidence, either personally or through other people, any prejudice involved can be avoided. And our submission is that on the facts of this particular application, serious prejudice can be avoided or remedied if any particular party wants to come before you. That by way of background, Chair. If I may then address the particular circumstances of the case. With Mr. McBride, of course, the Chair is aware that he was here in February. Some 30 to 50 notices have been considered since then, and quite frankly, although the work could have been done, it wasn't done owing to the fact that those responsible, and ultimately myself, Chair, for the issuing of the notices were otherwise engaged. Notices have been prepared and they're going out today. In that circumstance, parties will have notice that Mr. McBride is intended, if you grant the application, to give evidence on Thursday. That should provide sufficient time, in our view, for a party to make arrangements to hear the evidence either through television or get a record or be present. The time for cross-examination will be far in excess. The time to make application for cross-examination will be in excess of 14 days, so there's no prejudice there.
Well, the time within which to make an application for leave to cross-examine remains the same, specified in the rules.
Yes, it's 2 weeks.
So an impression mustn't be created that if I grant a postponement, people have more time than 14 days to file an application for leave to cross-examine.
That's a very good point, and I should be castigated for trying to gild the lily. Chair, it's, you're quite correct, Chair. The 14 days remains the 14 days, and that is indeed correct. So the full 14 days afforded by the rules remains intact. In relation to General Boyson, his evidence was planned for Thursday and will be postponed till Monday or soon thereafter as he may be heard, because it's not clear how long Mr. McBride's evidence will take. We're estimating and will attempt to complete it within 2 days. His evidence was due to be heard on Thursday, and if it can be heard on Monday, the position is that people can make arrangements to hear or be present to hear the evidence, and then the 14-day period will run from today or tomorrow. I must say that logistically, the administrative team in the Commission's office is dealing with approximately 100 notices for both witnesses, and so the backlog is perhaps inevitable. In order to reassure the public, Chair, you are obviously aware of the planned increase in capacity, both on the attorney assistant side and on the administrative side, which, barring any hurdles, should be in place within the next few weeks. So we hope to avoid this situation in future.
Well, the bottom line is that we are in this situation where, once again, an application is made for the postponement of Mr. McBride's evidence, because despite the fact that a postponement was granted on the 18th of February, precisely for the purpose that Rule 3.3 notices should be served on implicated persons, the legal team failed to make sure over a period of around, 6 weeks, to make sure that the notices were sent to implicated persons. That's not acceptable. When Mr. McBride's statement was available last time, I take it that it was complete with all annexures, and all that remained was that copies be made and be sent out. And now we have to postpone his evidence again. You have indicated that the legal team takes a full responsibility for this. I appreciate that the legal team and everybody are working extremely hard and that they are very busy. But there simply can be no excuse for this not having been done. I'm sure that this experience will result in measures being put in place to make sure that there is no repeat of this kind of mistake. The Commission does not have a lot of time left before it finishes its work within the time prescribed to it. Therefore, we need every hour, we need to use every hour and every minute that we have to do the work and to hear witnesses. So, that it's unacceptable should be made quite clear and unequivocally. Fortunately, the rules of the Commission do seek to make provision that would eliminate, as far as possible, any serious prejudice to implicated persons. We have maintained from the inception of the Commission that the rights of implicated persons are important, that everyone must be treated fairly, and that includes all implicated persons. They will be treated fairly in this Commission, and we will do all we can to respect their rights. Where mistakes have happened, it is important that responsibility be taken and that steps be taken to make sure that there is no repeat, or that prospects of a repeat are seriously reduced. I am prepared to grant the adjournment as requested, in the hope that we will not have a repeat of this. Of course, we mustn't overlook any inconvenience to the witnesses themselves, who keep on making themselves available and find that there must be an adjournment. That is important. It is important that we make known that we also have regard to their convenience as well. I will therefore grant an adjournment of Mr. McBride's, of the hearing of Mr. McBride's evidence from today to Thursday this week, and that of General Poison from Thursday to Monday, from Thursday this week to Monday next week. His evidence being subject to when Mr. McBride completes his own evidence. So therefore, the evidence of those two witnesses, the hearing of the evidence of those two witnesses is adjourned as I have indicated. The implication of that is, of course, that therefore there will be no hearing of any evidence this week until Thursday morning. On Thursday, Mr. Pretorius, shouldn't we start earlier than normal, seeing that we are losing time?
We can, Chair, but apart from Mr. McBride and General Boyson, there are no witnesses from law enforcement agencies planned for this week and next week. And then the interposition of evidence regarding Transnet is planned. But happy to start earlier, say 9:30 would be convenient, because one needs to prepare as well. There's a lot of work still to be done.
Yes.
There will be an opening statement
Yes.
Before Mr. McBride gives evidence.
Yes.
And there may be a need for an application, which I will discuss with you in chambers.
Yes. How long is the opening statement likely to take? Because that may be relevant to the question of when we should start and
Between 1 and 2 hours, Chair.
when he's likely to finish his evidence. Because from what you have said, we should try and aim at making sure that he finishes his evidence on Friday. So you say the opening statement might be 3 hours?
No, between 1 and 2 hours.
Between 1 and 2 hours.
I can try and restrict it to 1 hour.
And what is your own estimate of how many hours his evidence is likely to be, even though it might be difficult to say?
Yes.
But, what's your estimate?
Chair, if all goes according to plan, and there are questions of a limited nature, and there's no need for lengthy explanations to explain evidence, we should be complete within 2 days. But one must make provision, at least in theory, for time for matters to be placed in context and
Yes.
collateral evidence to be given in order to
Yes.
clarify what is being said by the witness.
Yes.
And my fear is that that may take us over Friday.
So we might have to then start early on Friday and add some time after 4 o'clock as well.
Yes, Chair.
Certainly on Thursday, and maybe Friday we might need to start early as well.
Yes, Chair.
we are going to have today, tomorrow, and Wednesday, which obviously will be used for a lot of other work that always needs the attention of the legal team as well as myself and everybody. But why shouldn't we start at 9 on Thursday? That gives you that 1 hour, which might be enough for the opening statement, but maybe you need another one. But if you have things to attend to, we could start at 9:30 and just add more time after 4.
I would prefer the latter solution.
9:30.
Yes, please.
Okay, then we'll start at 9:30, and then we won't finish at 4. We will go at least up to 5, and then on Friday start early. You'll just have to remind me on Thursday to indicate what time we would start on Friday. We might have to start a little earlier, but also it will depend on progress that we will have made by end of the day on Thursday. We are going to adjourn the proceedings then until 9:30 on Thursday for the hearing of Mr. McBride's evidence. We adjourn.
Thank you.
All right.